in this investigation, the detectives can't be trusted. They're not following the truth. They're not after justice or truth or anything like that. They are out to prove what they believe happened. And that's it. That's all they're interested in. Had they investigated this properly, they would have been looking at the officers in the department that actually, well, for one, the one officer in the department that had a history of having sex with prostitutes while on duty in uniform. That should have been a place to go look. Rocky Gregory says he didn't even know about that guy. That he didn't even know about a guy who got fired and had to get rehired because of binding arbitration, who had been fired for banging prostitutes while on duty. He didn't know about this guy. I'm supposed to believe that. Okay, I'm not calling Rocky Gregory a liar, but that's hard to swallow, Rocky, that you didn't know about that guy. So, judging that I do know you lied about other things, it seems likely, although I'm not accusing you, it seems likely that you did know who that guy was, and you were deliberately ignoring him.
Get on the train before it leaves the station. The truth train is coming, gonna run them down.
If you can't back up that it is vaginal fluid, then you shouldn't be allowed to say it. In my opinion, you shouldn't be allowed to say it. Any thoughts, Trav?
Yeah, I've got some thoughts. DNA science cannot reach conclusions of fact like that it's vaginal fluid. And so, but it was stated as DNA science. So, talking about parallels, sweat DNA doesn't exist. Created, we think, most likely because there were serious concerns that the defense could raise planting evidence with that vial of blood. And so they swabbed the hood latch, came up with this sweat DNA thing. Can't carry around a vial of sweat.
Right.
But this zipper thing, my understanding is there's female DNA that they've tied to a person, but Daniel's DNA is not on the zipper fly. And so she concludes Elaine Taylor, apparently disgraced in some sort of way with regard to her employment as a lab tech, DNA tech person.
Right.
So she concludes, okay, since there's female DNA on there, but none of Daniel's, it must be vaginal fluid.
Right.
Well, how do you get to that? And then the prosecutor argues in closing that, ladies and gentlemen, it's a scientific fact. It's a DNA fact. It's vaginal fluid. When that's not the science. And then going back, to the point we just covered, they won't allow the defense to turn over all of this testimony in this 2-day secret hearing regarding Elaine Taylor. They won't let that be turned over to their own expert, Michael Spence, to review it. And Spencer, who's their DNA expert.
Right.
I think there's also an allegation that, and again, I'm really excited to get the transcripts to review, but it's also my understanding that Daniel's defense team did not have a DNA expert, and part of what they argued in the direct appeal was that it was ineffective assistance of counsel not to have a DNA expert.
Right.
And, there's another parallel.
Right.
If you don't have the right experts, whether it be blood spatter or DNA or false confessions, you can't just rely on, oh, well, I'm an expert in firearms and ballistics. I can cross-examine their ballistics person. Well, that may be, but you start going up this ladder of scientific expertise and start getting into DNA, you need an expert by your side saying, hey, man, object, this is total bullshit.
Right.
And
right.
Just like with bite mark stuff.
Right.
And
so it's moving
microscopic
forward,
hair comparison,
yeah.
there are cases where this evidence later determined it just can't tell you what. We're talking about FBI lab analysts saying, oh, this is a positive match, and then it turns out no. And that's just something that everybody deserves, whether you're a public official, a police officer. You deserve in your trial to have what science can reliably say about the evidence in your case and no more.
Right.
And it's the goal of a criminal trial, and what the purpose of the DA is to fulfill their ethical mandate, is to see that justice is done. Not a win in the win column.
Right.
And so that's one of the big issues at play is what level do you have to show? Do you have to show that the prosecutor knew the lab tech was lying? Do you have to show that, if it fundamentally undermined that a fair trial occurred because of the exaggerations or overstatements made by the lab tech, should you get a new trial? And that's what Daniel also tried to get the Supreme Court to entertain, and unfortunately they didn't. But he still has his post-conviction motion that he can file, and they are working on that. But there's some very fundamental legal issues at play here that I hope get fully developed in the post-conviction motion and can be brought out. Because it's tough to win an appeal in a criminal case based on witness credibility.
Yes, I understand that.
Yeah,
don't take it too seriously, right? I get that.
But it's important. Paul and I had an offline conversation a few days ago about the scientific basis for false confession testimony, and whether anyone had been exonerated solely upon the testimony or the scientific basis background of the false conviction testimony, and I got to thinking, I can't think of one offhand, but it's just because of the fundamental nature of how you present these things. In post-conviction, it's pretty much got to be a constitutional claim. So that leaves us either Brady,
Right.
or ineffective assistance of counsel, which is how Dr. Leo did it in his affidavit on Brendan's case. His either last or second to last conclusion was ineffective assistance of counsel.
Right.
But if they had prevailed on that case, it primarily would have been because of that field of false confessions.
Right.
Has been built up and evolved over the years, to where, it's now accepted.
Being accepted
Because
or
of-
being taken
because of those-
seriously. Right.
Yeah, but because of those DNA exonerations, exactly the things Paul has been pulling out, with the articles he's been reviewing on his channel and on the false conviction. But, getting back to this point, you can't look at this stuff in a vacuum. It all kind of fits together. Right. So if you can explain, okay, yeah, it started with alleged victim 1, and then they went out and interviewed over 40 women, either by developing a list or whatever, and they do these other things, and then they get to this flawed DNA evidence. If you can put the whole picture in context, just like with a false confession, that here's this guy's uncle, they've got a super weak case, they're floundering, they don't have anything, they hear something about this individual, and then he's interviewed, and lo and behold, you have all of this stuff magically appear. Without the context of it, I don't know of a case that's been solely based on the scientific background and of false confessions that people like Dr. Leo and Dr. Offshay have developed. But I know that it's a fundamental part of it, and you do want to look at, are there problems with the stories, because that kind of tells you how did we get from A to B to C. And A is the initial complaint, and then B is talking to these people, and so you do want to see, was this brought out at trial?
Right.
There are a lot of things with Brendan and Stephen's cases that people bring up, which they should, fundamental problems in the case. 90% of were brought out by Strang and Buting at trial, that for whatever reason just didn't resonate enough
right.
with the jury, or constitute reasonable doubt. And so I think it's important for people that are interested in looking at false convictions and how do they work. And this is the reason why in Daniel's case, I suspect that a lot of these credibility issues were brought out during the trial by defense counsel. Mm-hmm. I bet that they exposed these credibility issues, and all things being equal would have raised a reasonable doubt in a lot of people's minds.
Right.
But this case, you have
so politically charged, as Daniel
DNA lab tech Elaine Taylor come in and say, this is vaginal fluid. And then you have a DA that it it underlines how important, like you were mentioning earlier,
Yeah.
forensic science is important to jurors
And
if
it
it's
is.
available.
And remember,
They will
folks,
ignore everything.
when I was talking to Dan, Dan said there is no test for vaginal fluid. So it's absolutely ridiculous for them to even claim it. Because there is no test to this day. There is no test for it.
And so why push the outside of the envelope by the prosecutors to suggest that it is? And it's because they've got a weak case factually,
Right.
or they have some victims potentially that have credibility problems or issues. I don't know. I haven't seen it, but
Yeah.
you know,
Like Tabitha Barnes
why
showing
do you
up high on PCP.
why do you overstate? And you overstate it because but that's why it's important to look at whether there's credibility issues with some of or all of the alleged 13 victims in this particular case.
Right.
Not to attack the women,
but to attack the investigation.
but to see, okay, well, how, why is it important for a court to determine the reliability of forensic evidence, whether it's DNA or whatever? It's because jurors put so much emphasis on scientific forensic evidence, to the point where if it turns out to be total bullshit, like hair strand comparison, certain types of bite mark, and on and for arson, certain types of arson stuff is totally debunked, and on and on and on, that the courts will say, oh well, it's harmless error. There was other corroborating evidence. Well, that shouldn't be the standard. If you're selling a bill of goods like forensic scientific evidence and DNA, you should be able to back it up, and you have a duty to safeguard that it's not going overboard. And if it turns out to go overboard, even if the DA has no intentional motive, it was
he wasn't
premeditated. It's like, too bad. You got to go back and do it over. But that's why I do think it's important to get the transcripts. What came out at trial? How was this addressed? But you could clearly see with what limited stuff that I've been able to review so far, there's just a fundamental problem about this vaginal fluid business, because there is no science behind that.
Right.
Trav, a quick question. We're talking obviously about, this, one of the claims that a lot of people go for is the ineffective assistance of counsel. And one of the claims is, failure to call experts on behalf of the defense. Is it not a terrible, sad state of affairs that you have to have two experts, one to contradict the other? If they're experts, they should agree on what the evidence, on what the evidence is. It seems that it seems to hark towards, what Sean Atwood was saying about, the courtroom is just theatre, where we hear it, don't we, about Michael West and the David Sorville one. The jury went with Michael West because he told a better story.
Right.
It's a terrible state of affairs that you can't have, dare I say it, neutral experts that come in and say, this is the evidence and this is what it proves.
Well, yeah, I agree. But it just depends on, the type of scientific evidence. So clearly, if someone is caught with they're pulled over and there's a legal search and they found a white powdery substance, state calls an expert, comes in and says it's cocaine. We'd hope that if the defense called an expert, they can agree on that, or they draw blood from you and your blood alcohol concentration is 0.12. We hope that the blood that they save in the vial, if you have independently tested, will be close or at 0.12. It's when we get into either soft expert testimony, which usually involves the social sciences, psychology and false confessions, things of that nature. You're never in the soft sciences going to get universal agreement. It's going to be a matter of interpretation. Is this person legally sound? But in talking about other types of scientific evidence and what conclusions you can reach, why it's ineffective is, one, you don't know if the wool's being pulled over your eyes as a lawyer, even if you're pretty much up on DNA. And so you bring in the expert not only just to testify, but to prepare you for cross-examination.
Right.
And so, and a lot of things, Paul, I think it's sad that there can't be fundamental agreement. I think one of the biggest that is on is blood spatter. Blood spatter, they say, it's based on physics and, it can be repeated. And we have Forensic Science Commission in Texas. It was established 4 or 5 years ago, partly because of the Michael Morton case. And one of the things, they do review certain types of evidence. One of the cases came up is a woman down in the Houston area, accused of murdering her husband, and Tom Bevel was brought down from Oklahoma. He does a lot of testimony for the state and defense, but he's pretty big in blood spatter in Southwest. And he testified in front of the commission, that one spatter mark is not enough to draw a scientific conclusion. Whereas the other experts that testified before the commission said that, no, you can tell enough from one spatter. And the commission left it status quo. One point in space is enough to backtrack and determine whatever it is that they say that they can determine. And so, Paul, that is disappointing that top experts in their field cannot agree as to what level you need to have a scientifically valid opinion. Similar maybe to the number of points on a fingerprint, which there's nothing established. People say 10 points all the time, but that's, they'll say, well, there is no minimum. And so that shows where it's subjective again. I get a feel for it. Or an investigator in a false confession case. Well, I was trained. I know when people are lying. And so, that's why I pulled these shenanigans to pull out a true confession. But no, that is sad. And part of this is there is a lot of money to be made in the expert witness business.
Right.
Yeah.
A lot of money in a lot of areas. Cell phone, bite mark if you have the dental degree, and on and on and on and on. I mean, a lot of money.
So we're talking incentives.
Yeah, so the point is, obviously, is
one
the
way or
soft
the other.
sciences have less defined parameters that, like you said, with the 7 points of a fingerprint. There's just less definition. It's harder to define because it's so subjective, basically, right?
Right. Well, but because there's this, greed just factors into a lot of things, and it can cause things to run off the rail. And so the state has a flimsy case, and whatever type of case, and all things point to a particular person. It's the only one they've got, and it's like, well, they go to a conference somewhere and they're like, talking to another prosecutor, I got this case, husband's dead in bed, shot to the back of the head. The wife calls it in, says she, stumbles upon it, but, we don't have anybody else. Oh, well, we got this expert, so-and-so, and he helped us out on this case. You should give him a call. And, then you start down that road, and, it happens with state lab people, even when there's no financial incentive. It becomes, an ego thing.
Right.
And they'll just really go out on a limb, shaken baby cases. A lot of bad stuff came in with that. Coroners came in, so we're talking MDs trained in a specialty, so they have at least a year, sometimes 2 years of additional training before they get licensed. They're board certified. They go to a seminar, and here's what we know about shaken baby, and then a year or two later, it turns out this medical evidence that they thought was indicative of shaken baby turns out, oh, well, here are those signs on X-ray or MRI or dissection. Here are those exact signs in a case that we know is not shaken baby.
Right.
And that got released, and then to their credit, these doctors, they read that stuff in the journals and they go, oh no.
Right.
I gave an opinion, and we've had that a couple of times in Travis County where they called up the prosecutor and the defense attorney and said, I gave testimony 5 years ago in a case, State v. X, and I think I'm wrong about it. And, unfortunately, not all experts do that, or you don't have that.
Conscientiousness.
But Paul, it is sad, but the problem is when we say stuff is scientific, 10% of it's science, 90% of it's interpretation of it.
Right.
And, you know, outside of blood alcohol concentrations, you know, things that are binary, you know, is this cocaine or isn't it, or is it flour? But you start to get into, and then we have all the issues with the practices in the lab and the, you know.
Well, we're at about 2 hours. I think we'll leave the discussion about the integrity for forensic sciences for another video. I think maybe, but it's a good topic. I would love to talk about it.
Well, yes, particularly Travis, because in one of my conversations with Ken Kratz, I asked him straight out. I said, "So Ken, has anybody ever written a book trying to claim that false confessions don't occur?" And he said, "Not to my knowledge. Maybe you'd like to read my book."
Right.
But yeah, no, I thought it was fascinating that, you know, the question you raised, you know, has anyone ever been exonerated solely based on the science and testimony of a false confession expert?